Right now on the Ag Issues program, a pleasure as always to bring back to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
It just dawned upon me we've turned over a new leaf to 2025, and someday I will remember this. How many years have we had you on the Ag Issues program now?
I think I started with Kelly in the spring of 1994. So we're coming up on 31 years.
31 years.
I'd have to go back and look, but I think it was spring of 94.
Absolutely. And, well, we've covered many of items that have taken place, and one that I don't think you and I have covered.
No, I didn't cover it with Kelly either. This is a brand new one.
Yeah, this is the Horse Protection Act of 1970, intended to end the inhumane practice by owners, trainers, and exhibitors of deliberately making sore the feet of the Tennessee walking horse. But starting February 1 of this year, I understand there's going to be new regulations that take effect that will expand the HPA, or Horse Protection Act, to all breeds of horse and all types of horse events, but that also would include 4-H events.
Yeah, that's the thing that needs to have people's ears perk up to on this one. This is why I'm bringing this up, because unless these are pulled or reversed somehow with a new administration coming in, I think these new regs are going to have an impact beyond what maybe it is the intent, but clearly beyond what the intent of the Horse Protection Act was when Congress created it in 1970. And as you said, that was designed to deal with the problem of soring a horse. These Tennessee walking horses, just so people are familiar with what I'm talking about, they're not that big of a deal around here. They're not raised around here, but you'll see them in parades. These are these high-stepping horses. And people may think, well, that takes a lot of training to do that. Well, yeah, it does if you do it right. The problem is that the Congress identified with the Horse Protection Act of 1970 is that trainers would sore the horses either by applying chemicals or putting a painful collar around the top of the hoof that would cause the animal to step up in a pronounced fashion. It would hurt when they put their foot down, so they pick it up real quick, and that's how they would get that effect. Well, the Horse Protection Act outlawed those types of procedures and termed it an inhumane practice if it was done in interstate commerce. So if you've got a horse and you take it to a show, a parade across state lines, then you got a problem. You got a violation of the Act, and there are civil as well as criminal penalties for violating the Act. Well, then in 1976, the Congress strengthened the enforcement provisions in the Horse Protection Act, and it prohibits the sored horses from being entered into horse shows and exhibitions and sales and auctions and moving in interstate commerce or substantially affecting commerce. That's what the language in the statute said. And it was also extended in 1976 to intrastate commerce, moving around inside a particular state. So that was the original intent of the law. And so if a horse had the appearance of being scarred, that scar itself could be enough to indicate the horse had been sored, which would trigger the application of the statute. And then you could get into penalties. And currently those penalties now, they've been adjusted for inflation over the years. Civil penalties are $5,000 for every violation, and an order disqualifying the person that did that from showing or exhibiting horses for a period of at least a year for the first violation, and then 5 years for any subsequent violation. And then if you violate your order of disqualification, it's a $5,000 penalty. And if you do that knowingly, it's a criminal violation, and your penalties are up to $3,000 and a year in prison for a first offense. And then it gets worse from there if you keep doing it.
So under the HPA, Horse Protection Act, the liability can extend to trainers as well. And I guess for the original intent and probably for what we see on some of the updated laws?
Yeah, that's right. And in fact, there's a really prominent. I cover the Horse Protection Act in my treatise, and there's a prominent case on this out of the Sixth Circuit. And of course, the Sixth Circuit comprises horse countries in the Sixth Circuit. That's going to include Kentucky as well as Tennessee in there, and that's a big issue there. That's where these horses are raised at. And under the Horse Protection Act, you're right, liability can extend to trainers if they enter a sword horse in a show, and owners who allow the sword horses to be entered. So owners have to pay attention to what the trainers are doing. Now, whether an owner is liable for the entry of a sword horse regardless of knowledge or fault, that's always been unsettled in the courts, and it's still unsettled. Now, the USDA's position, because the USDA has regulatory authority under the Horse Protection Act, so this routes back to the USDA. Their position is that an owner is liable regardless of knowledge or fault for a sore horse. So USDA is interpreting the act in a manner that doesn't require them to prove the owner is somehow responsible for the soring, either directly or not. But the statute appears to differentiate from those who either directly enter, show, or exhibit horses and those that don't. So that's never been something that's been cleared up by the courts, and we don't see too many cases on this. We did have a case in 2003 where the 10th Circuit, which is what we're in Kansas, adopted the USDA's position that an owner is liable regardless of knowledge or fault for a sore horse. And that case, they tried to get the U.S. Supreme Court to take that case. The U.S. Supreme Court declined to take it. So that was really kind of the last big court cases we've had on this until we get to what now will be regulations that take effect February 1st.
So with the revisions as far as the changes are concerned, there are a lot of things or a lot more involvement as far as events are concerned, say, for instance, 4-H events that take place. So let's take a look at some of those as well. And they're pretty significant changes, and especially if you are hosting an event, some of the responsibilities for event management.
Yeah, that's right. And these rules are a result of animal activists that have sought more regulation of the Tennessee walking horse industry. And they wanted an expanded definition of soring to cover as much of the entire horse industry as possible. So now the regs are going to move beyond Tennessee walking horses. And this is where now those of us in Kansas and other parts of the country have to pay attention to what these rules are going to be. And so in terms, if I'm an event manager or I'm an owner or I'm running a program involving horses, you have to pay attention to this. So if I'm an event manager, I have to notify the USDA's APHIS, their Animal Plant Health Inspection Service, because that's the regulatory body within USDA that is responsible for all of this. I have to give them 30 days notice before I do an event. And so any event, whether I have a violation or not. So I have to tell the government I'm going to do an event that has horses in it. And I also have to tell them whether I have appointed a USDA horse protection inspector or requested an APHIS veterinary medical officer to conduct inspection. So you got to get that lined up too. Now, that dovetails in with another problem, and that is we used to have a program where you could have a designated qualified person to do your inspection. They're discontinuing that simultaneously. So all these private veterinarians, now you can't use a private veterinarian anymore. You're going to have to go to a government-approved veterinarian, which is going to limit the supply of possible veterinarians. So you really have to plan far in advance. If you're going to have a horse show or a 4-H event that's going to use horses, you got to give notice at least 30 days. You got to have your veterinarians lined up through the government. And then any updates of what you're doing, you have to provide that 15 days in advance, and you have to report then any violation of the Horse Protection Act to the regional director of APHIS within 5 days after the event concludes. So a whole bunch of hoops, a lot more regulatory hoops you have to jump through if you're going to do an event involving a horse.
And also inspection protocols, in this case, the HPIs that USDA will be training and authorizing that I assume this would probably go under licensed veterinarians or individuals who have that extensive equine experience?
Yeah, those horse protection inspectors, that's HPI is the acronym for that. Those are those USDA approved inspectors. They will be licensed veterinarians or individuals with extensive equine experience that the government approves. And they're the ones that are responsible for doing the inspections at the event. Now, the event managers are liable for any HPA violations if they choose not to hire an inspector. But these inspectors are to have free and uninhibited access to your records, your barns, your horse trailers, your stables, your stalls, your arenas, all other shows or exhibition grounds. It is comprehensive. They have to have access to absolutely everything.
Talk about the designated qualified person program, or in this case, it would be the elimination of the DQP program.
Yeah, that's the third party that I mentioned a moment ago. I could hire, for example, and before these regs come out, I could still do it for 3 more weeks. I could hire a private veterinarian. My veterinarian. I want my veterinarian to inspect my horses. They're familiar with my horses. I trust them. And no longer will you be able to do that. You have to have a USDA approved veterinarian. Now, you can't use your vet unless your vet is approved by USDA. That might raise another issue that I don't see the regs addressing. But they're discontinuing that program, which will necessarily limit the supply of veterinarians available to do all of this work that's required under the regs for you so that you can have a horse event. I can see bottlenecks and problems coming associated with that, but because they're doing that simultaneously, there's no phase-in on that elimination.
And the use of equipment and or substances to help the hoof in some form or fashion, would those be restricted?
Yeah, this is, I think, the way I read the reg, I think this is specific to Tennessee walking horses because they say that the use of action devices and pads by Tennessee walking horses and racking the horses during competitions is prohibited. Weighted shoes and bands, you can still use those. So I think the way that's written, that leads me to believe, okay, that is particular to Tennessee walking horses because we don't do those types of things with other breeds of horses. So it's not crystal clear in the reg, but I think that one is particular to Tennessee walking horses. But
this would also take a look at any type of substances, salves or whatever the case may be. Mm-hmm. Would that also just apply to the Tennessee walking horses?
I think so. That's my read of it. We may have to have an interpretation. Somebody will probably ask for an interpretation from USDA APHIS on this, but they are banning lubricants, anything that would mask the soring of the horse so that you can't see it upon inspection. And I think because those types of activities are only done with respect to Tennessee walking horses, that reg only makes sense in that context. But we shall see.
And also that means potential of the modification of a SCAR rule that takes place that also looks at the in things that are indicative of soring.
Yeah, the reg says that the inspectors are supposed to use their best judgment to determine if a horse is showing signs of soring based on dermatological conditions that would indicate soring. So that one looks like it's left up to the individual judgment of the government-approved veterinarian in this particular case.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest. We're discussing the Horse Protection Act of 1970, but updated regulations that will take effect starting February 1st of this year. And we've been talking about some of the specific things that are associated with the rule. But, Roger, one thing we haven't had a chance to talk about is specific rules if you are a horse owner that are going to change too.
Yeah, there's a whole list of rules for horse owners, not just people that manage horse events, but owners. And basically, you can't use anything that would make a horse sore, lame, or irritated. Any of those types of substances are prohibited. Anything that would make a horse have any type of inflammatory reaction is prohibited, and that includes therapeutic liniment. That could be an issue for people. You just can't use, under these regs, they're pretty tight on banning any type of substances that you would use on a horse, including skin and hair conditioners or even fly spray that would potentially cause any type of inflammatory reaction. And horse owners, Greg, are not the only ones that are liable. Any participant with horses is subject to liability, and that includes agents and haulers and trainers and vendors and supporters and sponsors. That's really broad. I really wonder what the application of that is going to be once they put this in practice. And there are mandatory rest periods that have to be observed during shows and exhibitions and sales and auctions. And any information that an inspector wants, you have to provide it on demand. You have to have it ready. And the horse's legs have to be blemish-free. That includes, they say, dermatological conditions such as any irritation, moisture, edema, any type of swelling or redness, and the list goes on and on. But I think you get the point here. These regs are very, very onerous, and there's going to have to be some meetings. Hopefully, K-State Extension will pick up on this for horse people across the state and provide that training. And I've got my piece out there now on this, and hopefully they'll use that in these meetings. And this is one of the things that wasn't scheduled for me to talk about tomorrow night in Garnett, but I may make it available. And by the way, that meeting, which is an extension meeting in Garnett, is switched now to online. So people in the Garnett area, and there are a lot of horse owners in the Garnett area. When we get into Amish areas, we see that, and they're going to become subject to these regs too. But the veterinarians, the HPIs, can detain a horse for 24 hours, and you've got to have, as an owner, complete vet records that you keep and maintain for your horses receiving therapeutic treatment of any kind, the reg says. So, and if you have a horse in a competition, the reg says if it wins first place in a class, it has to be re-inspected. So get that. So that's pretty tough. And I think the problem here is that the reach of these revisions, because it extends to all shows involving horses, that's going to pick up your local 4-H play days all the way to annual international competition. So it is across the board, and it's going to be a burden for people to get caught up with respect to what these regs require.
Roger, before we end the program, we talked about this a couple of weeks ago, but you've got coming up here in 17 days on the 24th. You've got a big event at the Washburn Law School, at least to look at and hopefully make a dent in the problem of the lack of attorneys and tax professionals in rural areas across the country.
That's right, Greg. It's on the 24th, which is a Friday, and that's the end of the first week that students are back in session at the law school for the regular semester. And I'll do the first 2 hours of continuing education, getting practitioners ready for tax season. Then the rest of the program throughout the day is trying to address this problem of a shortage of rural attorneys, shortage of rural CPAs, shortage of accountants in rural areas, not just in Kansas, but across the country. And this is a big job fair, not only for our students, but the business students at KU and at Washburn and at K-State to come in. And if you're interested in learning about what the needs are in a rural community, in a county seat town, in a smaller town practice, there are practitioners coming in from all across the country. It's a big job fair. And we hope to make connections through all this networking for our students and, like I said, for business students at the other colleges in Kansas nearby.
All right, Roger, and if anyone wants more information about the HPA laws, the updated HPA laws, they can find that on your blog?
They can, yes, and I'll share that today, although K-State is closed again today. I'll send that over to K-State, and it'll appear on Ag Manager.
All right, sounds good. Roger, as always, I appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us this morning on the Ag Issues program here on 580 WIBW.